One, we appreciate your participation, your lawyers and the clients on this participation in doing this process this way. It enables the Court of Appeals to continue its work, which is the work of the people of the state of Tennessee. Mr. Hibner and the IT people at the OC have done a wonderful job of leading us through this process and getting it so that the technology generally works pretty well, almost always. But if there should be a problem, we'll just take a short pause and we'll resolve it and move on from there. Call the case, please, Mr. Hibner.
Daphne Saunders versus Y-12 Federal Credit Union.
We'll hear from the appellant.
Thank you. May it please the court. Michael Wall on behalf of the appellant Daphne Saunders. Ms. Saunders is appealing an order that dismissed her complaint for failure to state a claim. The legal standard that governs this motion is well understood. The defendant, Y-12, has to show that Ms. Saunders cannot prevail in her case under any set of facts. In making this showing, Y-12 may only rely on the pleading and the contract attached to the pleading. And Y-12 has to show that the contract has unambiguous language that forecloses a case by Ms. Saunders. Even if the contract is ambiguous, then this motion must be denied because ambiguous contracts are construed against the drafter. In this case, that's Y-12. And also, parties are entitled to present extrinsic evidence on the meaning of an ambiguous contract. And that can't happen on a motion to dismiss. So because of the posture of the case, we think Y-12 has a pretty steep burden to succeed, and respectfully, we don't think it's met that burden. Ms. Saunders has three legal claims: breach of contract, breach of the duty of good faith, and unjust enrichment, but they all boil down to the same basic question. How many times can Y-12 charge a customer when she overdraws her account? Ms. Saunders tried to pay her AT&T bill electronically out of her checking account. It turned out she didn't have enough money in the account to do that. So Y-12 returned or rejected the request for payment for insufficient funds, and it imposed a $32 non-sufficient funds fee, or NSF fee, on Ms. Saunders. Now, a few days later, Y-12 looked at it again, the same attempted payment to AT&T, and it said, well, she still doesn't have enough money to pay that bill, so we're going to impose a second NSF fee. And then a couple days later, Y-12 looked at it again. We're still talking about the same attempted payment to AT&T, and it imposed a third NSF fee. So Ms. Saunders recognizes that, if she made a mistake and overdrew her account, she owes a fee. And in fact, right off the bat in her complaint, she conceded owing one fee. What we dispute is that Ms. Saunders owes 2, 3, or potentially even more fees for the same exact thing. We've probably all overdrawn our account at some point in our lives. You hate doing it, but you're going to have to pay a fee. You don't expect to pay numerous fees for the same thing. And it doesn't go without saying that a customer would have to do that. If the credit union or bank wants to reserve the ability to charge duplicative fees like that, then it needs to say so clearly in the contract that it drafts, because Y-12 here was solely responsible for drafting.
Let me interrupt you real quick. The operative language, I think, in the member agreement speaks to the fact that the bank can charge for each overdraft. So I think that's what the trial court honed in on, was the use of the word each means that there might be multiple overdrafts. So what do you say about that language?
Right, that is correct. It says one charge for each overdraft. And our submission is that when you have an attempted payment and it doesn't go through, that is an overdraft. She initiated that. That is, in the language of the contract, an item or transaction. But when that's same thing is resubmitted or reprocessed by Y-12, that is not a new and separate thing. It's not a different overdraft. It's not a different item.
Was there any evidence introduced about what Y-12's policy is with respect to how many times they will try to run something that has had an NSF come up?
Y-12 did submit some things that are outside the pleading. They have to do with these NACHA rules. We would submit that they're not properly considered on a motion to dismiss because, again, they're outside the pleading and the contract. But those NACHA rules suggest that a merchant's bank can try up to 3 times to get paid on something. But again, to make our point, we think that's for another day. It's summary judgment maybe, but not for now. So we've given the court 13 decisions from different courts that have addressed this very same kind of breach of contract claim. They're from different jurisdictions. I'm not suggesting they're binding on the court, but they are very persuasive. The first reason they're persuasive is there are just so many of them. And in fairness to the circuit court in this case, it didn't have most of these decisions when it dismissed Ms. Saunders' case. I think we only had 3 of them at that time. So it wasn't such of a landslide as it is today. But two of these cases are from Tennessee business court. So we know the court was applying Tennessee's motion to dismiss standard and contract law. And if I could recommend one of them in particular for the court to look at, it would be Romora versus Tennessee Credit Union, because that case had essentially identical contract language in paragraph 14A. I think this is a form contract that gets passed around between credit unions. And the court said, Chancellor Martin said that because item, it comes down to the word item. You know, when it's resubmitted to Y-12, or in that case, Tennessee Credit Union, or when it's reprocessed, is that a new item or is that the same item as originally was looked at? And that's what it really comes down to if you get down to it. And the chancellor said, and we think correctly, well, the contract doesn't define this crucial term, even though it's right to charge the overdraft hinges on that. And so you could argue it either way. You know, you could say, well, it's the same item or it's a brand new item, reasonably. And that by definition is an ambiguous contract. If the contract's ambiguous, then the law is pretty clear that a court can't grant a motion to dismiss. We actually think this court could go a step further and say that because of some other language we've pointed out, that it positively prohibits Y-12 from charging duplicative fees on the same overdraft. And I'll quickly get to that. So we start with 14A, as you did, Judge Davis. It says a charge for each overdraft. That means just one charge for every overdraft. And then it defines overdraft as, and I'll paraphrase it, basically, you have to have an item or a transaction. It has to post to the account. And then the amount of that has to exceed the available balance. So those 3 things have to come together to have an overdraft. So I'm going to start off with the item or transaction part. If you go a little bit further down in the contract to the EFT disclosures, this was an electronic payment, and we're looking at the electronic funds transfer disclosures. This starts on page 15 of the contract. It says, and I've tried to highlight this in our appendix because it's kind of hard to read this fine print, but it's on the left-hand side. If you initiate a transaction that overdraws your account, you agree to make an immediate payment of any overdrafts together with any service charges to the credit union. So you here is referring to the customer. It's addressed from Y-12's perspective to the customer. So this is talking about the customer initiating a transaction. So transaction or item is talking about what happens between the customer and the merchant. In this case, Ms. Saunders and AT&T. It's not talking about what happens between the credit union and another bank or something. It has to be initiated by the customer. And then a little bit further down on page 20, in a section entitled Member Liability, it says you are responsible for all EFT transactions you authorize. So here in 2 places, we see that the contract is contemplating that an item or transaction starts with the customer. She has to do something to cause an item or transaction. And we've recognized that Ms. Saunders did that when she initially tried to pay AT&T. She tried to pay her bill. She initiated or authorized that item, and therefore she concedes that she owes one. We have one item, one overdraft, and one permissible NSF fee. But she didn't do anything to initiate the reprocessing days later. And our complaint alleges this, explicitly a couple times. She didn't even know that was occurring. So that cannot reasonably be called an item or transaction based on the indications of what those terms mean from the contract. I kind of wish we had an explicit definition, but Y-12 did not give us that. So we got to go with what we have, and what we have is these EFT disclosures.
Counsel, let me ask you, this was a motion to dismiss granted, right?
That's right.
All right. Did the complaint make any allegations one way or another as to why it was charged 3 times, that it was resubmitted, or just what did the complaint itself allege on that?
The complaint just says that Y-12 reprocessed it. That's all the complaint says about that.
That's all the complaint says. Okay.
That's right.
All right. So there's nothing in the complaint about it was resubmitted because the merchants resubmitted it.
Nothing in the complaint about that. That is customary, and I would not be shocked to find out that that's what happened at summary judgment or something after discovery. But
we
at this
rarely
point,
go on what's customary.
right? I mean,
Motions.
well,
I'm sorry.
I'm sorry. I think I'm talking over you, and I apologize.
That's fine.
If I understood your question, then I think that all we know is we can suppose, but we don't really know from the complaint. It just says it was reprocessed. So that's in a nutshell our first of four really contractual language arguments, and the other three I don't really have time to address them all, but basically we argue too that this reprocessing doesn't cause the same thing to post more than once. Again, the contract doesn't define what posting means. It's a little mysterious, and maybe another reason why the contract is ambiguous, but just allowing something to stay a failed transaction doesn't seem to be a significant enough event to be called posting like the first time is. Also, there's a special provision in 14A that says that the credit union is only going to review the account once to determine whether sufficient funds exist to pay an item. So here it's reviewed at 3 times. And finally, the paragraph 14A says that the customer is going to pay the same fee regardless of whether Y-12 pays or returns the overdraft. So what Y-12 is actually doing here is if it pays the overdraft, you only get charged 1 fee, and that ends the item. But if it returns the overdraft, like it did with Ms. Saunders, you end up paying 2 or 3 fees, and that asymmetrical treatment is not consistent with what 14A says. So for all these reasons, we're asking the court to reverse.
We'll hear from the appellee. Appellant, you have your time for rebuttal. Hear from the appellee. You're muted, Mr. Wilson. You need to unmute.
Sorry. Yeah,
That's
can you hear
fine.
me now? Sorry about that.
Believe me, it happens a lot. To me, mostly.
Good afternoon. My name is Brandon Wilson, and I represent Y-12 Federal Credit Union. As you just heard from Mr. Wall, Ms. Saunders admits in this case that she made purchases without money in her Y-12 checking account to pay for them. And when that happens, Ms. Saunders agrees with Y-12 that she may be charged an NSF fee. Her complaint, however, alleges that when her ACH transactions are declined by Y-12 and then later submitted again by her merchant for payment a second or even a third time, Y-12 should not charge her an NSF fee.
Let me ask you, does the complaint allege that the second and third payments came because the merchant resubmitted?
No, quite the opposite, Your Honor. What the complaint alleges is that Y-12 took some affirmative action on its own to submit those transactions the second and third time.
Well,
And I think
on this motion to dismiss, don't we just look at what the complaint alleges?
not with blinders on, Your Honor, and let me explain a little bit. The account agreement at issue in this case on page 23 indicates that it's governed by, I believe, Tennessee law, but more importantly, it's governed by the ACH rules. And as we've pointed out, I think in detail in our papers, the ACH rules are very clear about what the role of the financial institution is and what the role of the merchant is. And it makes clear that the credit union does not take those transactions and resubmit them on its own. What it says is that it is obligated, it must accept those transactions only subject to its right of return. And so that's exactly what happened in this case. It also says, those rules also say that financial institutions must accept those transactions only subject to their right of return. And that each ACH transaction, even if it's a resubmission, is a new item with its own unique identifying trace number. And so Y-12 does not, as a matter of law, Your Honor, as Ms. Saunders alleges, actually take any affirmative action to reinitiate a previously returned ACH transaction. And each transaction, in fact, is a new transaction. If we look at what the contract claim says, Ms. Saunders alleges that the account agreement, quote, indicates that only a single $32 NSF fee will be charged for each item. However many times that item is reprocessed. That's the complaint at paragraph 13. But if we look at the account agreement, it actually doesn't say any such thing. It says, quote, if on any day the available funds in your share or deposit account are not sufficient to pay the full amount of a check, draft, transaction, or other item posted to your account, then you can be charged a fee. Why that's important, Your Honor, is that the account agreement is drafted broadly enough to encompass any and all checks, drafts, transactions, or other items, regardless of whether they're an original ACH or one that's resubmitted a second or third time by the merchant.
Excuse me for interrupting. Is the contract term each overdraft defined in the contract? And if not, is that not ambiguous?
So the contract defines an overdraft, Your Honor, as an instance when on a day there's not sufficient available funds in your account to pay the full amount of a check, draft, transaction, or other item posted to your account. So whether it's a check or an ACH or a debit card transaction, if it posts to Ms. Saunders' account and she doesn't have sufficient available funds, that the contract defines all of those things as an overdraft. And when an overdraft happens, the account is subject to a fee.
What is meant by each overdraft?
So I think the plain language of each, Your Honor, and each overdraft is each and every time that happens. And again, there is no distinction in the account agreement about whether it's a first submission, a second, or a third. And let me give you an example that I think is helpful in understanding the concept. In the Lambert case, the court talked about this argument that, hey, is an ACH resubmission the same transaction or same item as a previously submitted one? And the court said unequivocally no. And the judge in that case analogized the ACH to a check. So if we think about checks, those are easier to think about conceptually. But if I write a check and I submit it to my bank and it's returned for NSF, I don't get to write the check again, submit it to my bank again without sufficient available funds and claim that that's somehow the same as the first check that bounced when I didn't have funds. And an ACH is essentially the same thing. It's an electronic check.
I believe you referenced Lambert. Is that correct?
Yes, sir.
Is that the case that's referenced in the brief and it's currently on appeal?
I believe it is referenced in the brief, Your Honor. I'm not sure if the appeal was dismissed or whether it's still pending, and I apologize for that. But I certainly supply the court with that authority.
We're referring to Lambert versus Navy Federal Credit Union, Eastern District of Virginia, 2019 decision. Is that correct?
That's correct, Your Honor.
All right. So we don't know the status of that case right now, whether it's still on appeal.
Yeah, I'm not aware of that as we sit here right now, but certainly we could find out.
Thank you.
So
Yes,
back, I hope I answered your question.
Yes,
but it's important that contractual language under Tennessee law can be broad without being ambiguous. And the complaint here alleges that an ACH transaction was submitted for posting on 3 days. It was January 27th, 2015, January 29th, and February 2nd. There's no dispute in this case that on each day, Ms. Saunders didn't have funds in her account to pay for those ACH transactions. And each is, therefore, according to the plain language of the agreement, subject to a fee. Mr. Wall talked a lot about the foreign jurisdiction cases that they believe, Ms. Saunders believes supports her claims in this case. And I think that makes sense. You know, when you have a clear contract like we do in this case, it's not surprising that you would go searching for authority to the contrary. And I would point out the reliance on Romore is we believe Romore actually supports our case, and that's for a few reasons. First, Chancellor Martin in that case was careful to say that when presented with many of the same cases, that these cases are contract cases, and each of them need to be looked at on their own. And so even Chancellor Martin wasn't willing to simply paint with broad strokes and rubber stamp the opposition to the motion. Second of all, if you actually look at page 4 of the Romore opinion, Chancellor Martin distinguishes our case. She says, quote, Some of these cases involve agreements with language modifying the definition of item or overdraft with on any day or similar language, and she cites our case. She also says, quote, all of these cases were decided based upon the particulars of the agreements at issue and the outcomes vary. It is difficult to find any one or more of them as instructive to the court or authoritative regarding how it should interpret the language in the account agreement and fee schedule in this case. And again, I think the court respectfully should resist the urge to simply say, well, everyone else is doing it, so will we. Again, I think the language in this case, Y-12's account agreement stands on its own. And as Chancellor Martin made clear, we actually have some qualifying language that sets our case apart.
Counsel, I guess I keep going back to it. What's in the complaint that shows what triggered the second and third overdraft charge?
To that point, Your Honor, what the plaintiff alleges, and again, the court doesn't have to accept this as true when A, it conflicts with the actual contract language, and B, it conflicts with the law that it governs the document, in this case, the ACH rules. But what Ms. Saunders has alleged is that Y-12 takes some affirmative step to take that previously returned ACH item, drag it back into the credit union, and charge a second or a third fee. And what the ACH rules make clear is that simply cannot and does not happen. The only party, and we've identified those 5 parties that are part of every ACH transaction, but the only party that has the authority to resubmit a return transaction is in fact the merchant here, AT&T. And so when Ms. Saunders says Y-12 did something affirmative to suck that transaction back in and charge multiple fees, it's simply untrue. The court does not have to accept it as being true, even on a Rule 12 motion, because again, the allegations in the complaint are accepted as true unless they clearly conflict with contractual or statutory language, or in this case, the ACH rules, which they do. Finally, there are claims in the complaint for breach of the covenant of good faith and fair dealing. Obviously, as we've explained in our papers, if there isn't a contract claim, there certainly can't be a breach of the covenant of good faith and fair dealing. In addition, the claim for unjust enrichment at a minimum, that claim was properly dismissed because it's couched on the very existence of a contract. Ms. Saunders says, in fact, in paragraph 78 and 79 of the complaint, quote, Ms. Saunders and Y-12 have contracted for account deposit, checking, ATM, and debit card services. And so with that allegation, she simply cannot make out a claim for unjust enrichment. I want to close by saying this. Ms. Saunders alleges that Y-12's practice of charging fees is extreme, abusive, it's counterintuitive. We think it's anything but that. And what I want to make clear is that this is really an issue between Ms. Saunders and her merchant. Mr. Wall has said repeatedly that she didn't authorize these transactions, these resubmissions. That's simply false. We know it's false because in footnote number 2 of our appeal brief, AT&T tells its customers who are enrolled in its ACH program that it's authorized to resubmit those transactions 1 or 2 times. And so although she may not be hitting the button, by enrolling in bill pay, she has an agreement with her merchant to pay those transactions. So unless the court has any other questions, we'd ask that the court affirm the trial court's decision.
I hear none. We'll hear from the appellant in rebuttal. You need to unmute. See, I told you it happens a lot.
I wanted to do that too, just so we felt even today.
That was kind of you.
I think it's apparent that that Y-12, for its defense, is relying on things primarily or exclusively outside the record at this motion to dismiss stage. My friend just cited a footnote in his appellate brief that in turn cites to AT&T's website. a forum with questions and answers. I mean, this has no connection to the complaint or the contract whatsoever. The NACHA rules, which feature more largely in Y-12's brief, these are not laws. These are the rules of a nonprofit association, and it's a rule book you have to buy. It's 500 pages or something, and it changes every year. And this is not something the court can take judicial notice of. Our complaint doesn't refer to it. The contract doesn't refer to it. So all of this we would submit cannot be considered. And because they're resting on that primarily or even exclusively, we would ask the court to not entertain those arguments. But I do want to make the point that we're not really running from the NACHA rules. We think that if we ever have to get into them at summary judgment, we're going to find NACHA rules that we like. And in fact, the bulletin that they've submitted actually says in it that when a merchant's bank reinitiates an entry, that's what they call it in their language, which is just another way of saying when they ask for money again from Y-12. The bulletin says that the merchant's bank has to be careful to make it clear that it's the same entry as the original one. It can't try to disguise it to make it look like a new entry. Well, entry is just, the contract calls it an item, NACHA calls it an entry, it's the same thing, but NACHA is recognizing there that when it's resubmitted for payment after non-sufficient funds, it's the same thing. So that's our theory of the case, that when it's resubmitted or reprocessed, it's the same item. Therefore, by definition, it's the same overdraft, just one, and Y-12 may only impose one fee. So I think if we stay focused on the contract, though, and the complaint, that there's no other choice, respectfully, but to reverse the dismissal. Addressing the cases, my understanding is the Lambert case has been settled, or at least they're trying to finalize that settlement. I do not believe it's been formally dismissed, the appeal, but we would expect that to happen in the near future. And that was one of just a couple cases that went the other way in favor of the credit union or the bank. So, and nobody really picked up on Lambert and followed that. That was an outlier decision with some different language in the contract. And we've tried to distinguish that in our briefs, and we would just direct the court to our briefs. But the Romore case, I think it's going to be very difficult for Y-12 to distinguish that, since the contract language in paragraph 14A is identical, except for one or two words that really have nothing to do with what we're talking about. And I don't believe Chancellor Martin was trying to distinguish a case with identical contract language. I think she merely meant to say she wasn't going to follow the circuit court's decision in this case. And of course, we would not ask this court to blindly follow any other court, but I do think it's significant that so many courts have looked at this kind of contract and said that this is not a slam dunk for the bank or credit union. It's ambiguous, or possibly even clear in favor of the customer. And I don't think the court should disregard that. A reasonable person at a minimum could agree with Ms. Saunders' interpretation of this contract with respect to overdrafts. And that's enough to get us past the motion to dismiss. Thank you.
Thanks to counsel for both sides. Mr. Hibner, if you would adjourn court till tomorrow morning, please.
This honorable court is now adjourned. Counsel, you may leave the meeting at this time.